Welcome back to the Psychosocial Safety Briefings from the Psychosocial Safety and Leadership Institute. I'm Nicole Turnbull, and if you listened to our last episode, you heard David Newey from Gillis Delaney Lawyers break down the New South Wales workers' comp changes. And in this issue, we're going to tackle something that's creating significant concern for employers. The new powers allowing unions to prosecute work health and safety breaches, including psychosocial hazards. Now, this is a major shift in enforcement, and David's back to help us understand what it actually means and what employers should do. David, thank you. Welcome back.
Good afternoon this time, Nicole.
Yes. Let's dive in. So, what powers do unions now have that they didn't before, and when does it start?
Well, it's all going now.
Yeah.
So, one of the most interesting and most, I suppose, profound problem that's going to confront employers, particularly those that have a unionised workforce, is that there's now the capacity for unions to prosecute an employer or a business for breaches of the work health safety legislation.
Mm.
Now, it's not a carte blanche. It's not just here you go, off you go, unions, you can do whatever. There are a number of prerequisites to them commencing proceedings, but there is a real incentive for unions to do this. And that's because the court can order that the fine that's ultimately imposed as a consequence of a breach is paid in whole or in part to the prosecutor, which, where it's the union, they will get at least a part of the fine that's imposed. Fines are moving up significantly at the moment for breaches of the WHS Act.
Mm.
You might find $1 million fines being delivered for people where fatalities occur. And they are very, very, very much putting strains on businesses where such a large penalty is imposed. So, with the incentive to be able to get a bag of cash, a union will be motivated to investigate the possibility of bringing a prosecution. Now, how does it do that? It must first consult the regulator.
Mhm.
Now, the regulator must decide not to prosecute, and if that occurs, then the union is free to do so. So that's the big ticket item for unions. It's a big concern across the industry, but it is only really where there is a unionised workforce, because if there's no members of a union on site, it really has no role to play. So I see that as a big change, but more a change that's going to force the hand of the regulator to prosecute.
Mm.
Because you might find that whilst there's the threat of unions doing this,
Yep.
we might find that there's not much opportunity because the regulator takes up the cause. The other thing the regulator has to do is it has to deal with submissions from people who are aggrieved or those who have suffered as a consequence of a workplace accident, where people can ask the regulator to do something or to take action, and they have to have a response from the regulator. It can be a negative response, but they've got to provide reasons, and that's going to find its way into the hands of the unions if in fact that's what's happening, because no doubt those people aggrieved will want to go and talk to the unions if they have been involved one way or other. So it's a very interesting conundrum we're going to face. Do I think there will be lots of prosecutions by unions? Probably not.
Mhm.
Do I think that the activity of unions will promote the prosecution by the regulator? Absolutely. So that's where I think that is going to be an issue. It's going to be very interesting when you look at the breadth of the duties that are now imposed by the Work Health Safety Act, in particular, the obligation to comply with the Managing Psychosocial Hazards at Work Code, which has been mandated effectively through regulations and the Act. And so a breach of that is something that needs to be addressed by a regulator. We've got a whole lot of additional inspectors being added to the safe work employment queue, and a large number of those are going to be purely focused on psychosocial hazards and investigating matters around that. And so we've got unions that will take up this, particularly as I mentioned in the last podcast, the financial services industry will be very much affected by this. So will be the health industry. So these will be two industries that psychosocial hazards will jump very much up as a reckoning piece for not only employers, but unions and regulators. So I see a little bit of activity, probably more in the realm of the regulator, but I do see that we're going to end up with a little bit more when it comes to prosecutions. But we shouldn't forget that there's a whole lot of additional tools available to deal with concerns about contraventions of the Act. So we've got workplace committees that have powers and powers to issue provisional improvement notices, which are interesting little beasts, because if there's a dispute about one of those, guess who has the power to go off to the Industrial Relations Commission and deal with that dispute? The union. So there is another form of dispute that can go to the IRC, a dispute over an improvement or a provisional improvement notice, essentially. The same happens where there is a dispute over a worker who chooses to stop work because a practice is unsafe. If there's a dispute over that, that will find its way into the IRC. And once again, it's not the employee that has the ability to bring that, it's actually the unions. So we are going to see a beefed up role for unions around workplace disputes. There's another interesting little area that is also going to be subject to disputes that can be brought by the union. They include return to work programs. So unions can take on a dispute if there's a dispute over a return to work for an injured or return to work program for an injured worker. So we are finding a lot more little levers that can be used to deal with potential contraventions of the Act, and including not complying with the Psychosocial Safety Code. Very interesting. And a financial incentive around that for unions to do it if they do bring a prosecution.
So can you walk us through that process? What has to happen before a union can prosecute an employer? Is there anything to add on what you just said? And yeah, do you know what that process is?
Yeah, well, I'll go one step back. So unions have a right where they have a permit holder to come into a workplace place and investigate a contravention. And that is the start of the evidence collecting process for the union. Now, one of the interesting things is we've just had passed the digital workplace processes legislation that regulates and now introduces a brand new duty that you're required to ensure that your digital work practices don't expose employees to excessive work demands. So the algorithms that exist, the processes that automatically assign rosters, and other AI tools that are available out there to help you get the job done, where they are creating excessive work demands, there's a duty to ensure that they don't. And unions have a right to come in and get access to those systems to evaluate and determine whether or not there's a contravention. This was just debated last week, just passed Parliament last week. There were a large number of employer associations, and the opposition spoke very strongly against the legislation because there were concerns about potential privacy breaches if information came into the hands of all of the people that could come and inspect the digital systems, in particular unions. So they might be privy to information that is accidentally disclosed. So this was one of the concerns. But here we have potential claims for excessive work demands that, on one view, we're going to see a union can come knock on the door and see whether or not it can detect any contravention. Now, after that, it will need to consult the regulator, say, this is what I've got. What do you think? Are you going to have a go and bring a prosecution? And if the answer is yes, leave it alone. What will usually happen is the regulator would carry out further investigations, gather the evidence it believes necessary to ground a prosecution and prove the facts to do that, and then bring a prosecution. They do so by filing an application in the commission, serving that on the person who has allegedly contravened. They will provide a statement of facts, which they believe are the facts that they will prove. In due course, there will be a prosecution brief delivered. That will include a whole lot of the material collected in the investigations, and then there will be the ultimate resolution of the prosecution, which would either be by a plea or by a hearing. And the important thing is you only are obliged to do things that are reasonably practicable. So there will be disputes from time to time of a prosecution, but at the same time, that's the process. And it's going to be, you breached the digital work code, you breached the psychosocial safety code, you failed to ensure the health and safety of work of your workers. There will be a whole ream of potential breaches that have or will occur. And it's because we've got a new duty created by Section 26A, a new duty created by Section 21A of the Work Health Safety Act, which have all just been inserted by the changes.
That's why I'm really grateful for this conversation to help clarify and give employers and workers the right information. And I'm not sure if you can answer this question, but with the new penalties and powers, why do you think it was included in the legislation?
The right to prosecute, or a union's right to prosecute, has always been a debated matter. It's not new. It's just not been implemented. It's not totally surprising, and I think it arises from the general, let's make safe work more accountable. If it's the policeman for safety matters, it ought to be dealing with contraventions. Now, when you have a contravention, there are a whole lot of possible outcomes, including warnings, cautions, accelerating to improvement notices and prohibition notices, to prevent work being done or to get improvements done, seizure of plant and equipment so it can be inspected. So there's a raft of options available. We also have enforceable undertakings. If someone is being prosecuted and they can propose an alternative by way of a deed that people will make a contribution to the industry, the community, and perhaps to themselves, then an enforceable undertaking can be floated and approved as an alternative to a prosecution. But they are not everyday events, whereas prosecutions are everyday events. Now, the other problem is that we've got not only duties on businesses, we have duties on people concerned in the management of those businesses, the directors, and we have got an obligation imposed on directors to exercise due diligence or ensure that there is due diligence when it comes to protecting the safety of workers and contractors on site and others who get exposed to the undertaking of the business. So this is another driver that will be there, because not only can businesses be prosecuted, but so can directors. Now, there is no clarity around the issue of whether or not, if the regulator brings a prosecution against one entity, being the business, whether the union could jump on and say, well, you're not bringing one against the director, perhaps we'll do that ourselves. So there is no clarity around that. However, that might be another reason that we find that prosecutions against directors become a little bit more flavour of the month for the regulator. They're a very different test. Yeah. It really is whether or not there's been due diligence applied, and it requires an entirely different set of investigations to basically see what a business has and what the director does to ensure the safety of everyone. But this is another little part in the equation, and that's uncertain at this stage.
So you've mentioned that the code of practice is now enforceable.
Yep.
What kinds of hazard breaches could actually lead to prosecution?
Excessive work demands. There you go, your first one. So someone will come in and say, well, you are flogging all of your people. You're pushing them too hard. The industry practice is this. Look at your job as an insurance company. You are requiring people to manage 50 claims. Other insurers are requiring them to manage 20. Why? What's the difference? And so excessive work demands will be a large issue. Performance management becomes another issue, because I call performance management dealing with the day-to-day ruminations of employment. And so each one of those exposes people to a psychosocial hazard. Now, we don't have, and in the last podcast, we chatted about the defences employers have and whether perception was relevant, whether issues about someone's concern about being performance managed could give rise to a psychological injury claim. All of that's out the window when it comes to work health safety. The issue is whether or not there's risk of harm, and whether or not that risk of harm manifests, whether or not those other tests apply, because they're not relevant to WHS prosecutions. So it's a very different world. So if there's a risk to health and there's a hazard and it can be eliminated or controlled, you've got to implement the control measures. So it beefs up the need to do a risk assessment when it comes to everything that you do. We'll never get to the stage where you have to do a risk assessment before you go and counsel an individual person. That's not the right approach. It's got to have a general approach to managing that process. And the key to everything is managing processes, having things documented, having decisions supported by evidence-based determinations, and making sure that you have the solution. We've all seen the wonderful 9-box risk assessments to work out what you need to do. And they're helpful. We all know what safe work method statements are, but I don't think you'll find a lot of safe work method statements in the workplace that deal with how to counsel a person when they're being performance managed. And that's something that people should think about and businesses should think about, and you should have a process. How do you deal with a person to A, inform them about your process, B, how to go about the initial interview with a person, how to take them from a complaint to a claim against someone. These are all what I think are processes that time needs to be spent on, so you have something that you can follow when something eventuates, and it will. So everyone will face a conflict. Everyone will face what is perceived to be excessive work demands. Everyone will face what some people will view are unreasonable management action in directing people what to do. But if you've got a process to follow, you've got to start. And that's the whole, back to, you need this big, wonderful book of 5 million safe operating procedures and risk assessments. That's not what you need. You need to evaluate risk, identify the hazards, and try to control them and document that. And it's simple. And it's, how do you do that? When it comes to psychosocial hazards, communication, contact, feedback. People try to use surveys, which have a useful tool, but they're not the answer. They're one of the steps in what you might try to do to put together a system that manages that process of assessment. It's all about assessing how your business is done, what people do, and how they can do so without being psychologically harmed.
Yeah. So if a union official arrives at a workplace tomorrow and they're exercising their right of entry, what should an employer do?
I think it's very confronting because you will be unused to that generally.
Yeah.
The person that attends will be a union delegate, if they're from a union, that is ticketed. They need to display or show you their right of entry into the workforce. When you get that, you are supposed to give them assistance. That doesn't mean you've got to show them around everywhere, etc., but you've got to make some resources available to them so they can sit in a room or do whatever else. And you have to make some access to certain areas and people. But this is not a right for them to come on and go and conduct interviews and interrupt your business. So sometimes there will be a dispute, and if there's a dispute over rights, guess where we go off to? We go off to the Industrial Relations Commission, and the union will deal with that. Now, there are penalties that can be imposed on an employer for hindering a delegate. And those penalties, I think they're around about $66,000 being the maximum. So it's not small change. It can be considerable. So, but generally, if you have a dispute that escalates, then there's not much point trying to do it yourself. you will need to have an industrial advocate or a lawyer become involved to manage a dispute that you're going to have over rights of access. Now, I think you're going to find a few of these when it comes to digital work systems and unions trying to flex their rights to get access to those. Because I'm sure there are some businesses that have very much AI-driven evaluation of work. And so that's where I see we're going to develop the case law that will support things. Now, the example I give you, the digital workplace legislation envisages guidelines being issued by SafeWork. So we're not going to operate in a vacuum. So there are going to be guidelines, and those guidelines are going to inform everyone about rights and how to manage things or manage attendance. They're going to be crucial. A bit like everything, when you get your idea, you kick it off, there's still a lot of background paperwork to be done. And so we're sitting here waiting for that. It was only a few days ago it was passed, and you don't create something unless you get it passed. So it'll be a little while. As for starting days, can't start till you get the guidelines. It would be too early. So I'd speculate everyone likes to pick dates that are well known. You might find 1 July is a good starting time. But I can assure you now, the IRC, which is the jurisdiction that's going to manage all of this, will have already pushed out on their website a whole lot of guides to deal with the information rather than the process. The process is yet to come, but there will be information about who to prosecute, who can bring prosecutes, whether or not unions can get a moiety of the fine, which they can, what is a workplace dispute, who's got the powers to bring it, whether the employer or whether the union is the only one that has the power, or if an employee can also bring the industrial dispute. Now, the industrial dispute's interesting because they can have a sit down, they have a conciliation, they can have an arbitration, they can issue interim directions that you should comply with, and if you don't comply with, you're not in trouble, but it's taken into account in terms of the overall dispute that you chose to disregard an interim direction. So all of these will be new matters for employers. Hopefully, employers don't get too many of them. However, you don't know. And it does give some concern that unions seem to be coming back with a strong role in the industrial relations system, which they've always had, but now they're getting more teeth.
Yes. And do you have any advice for organizations that might not have great relationships or poor relationships with unions or workers? Is this kind of a reset moment? Should they try and come together, or any advice on that front?
Not really. Businesses will have relationships with whoever they have to deal with at the moment. That will be their workers, that will be their unions, that will be their safety committees that they've established. Collaboration and consultation in the workplace, key. So particularly when it comes to workplace safety committees and the like. So if you keep all of that happy, then we're not going to bubble up so significantly. If you're a non-unionised workplace, there will not be a lot that will impact from the introduction of these additional powers. If you are a very unionised workplace, transport companies, stevedoring companies, we have a whole lot of areas, the construction industry, there are a lot of businesses that might get an increased focus.
Mhm.
Dealing with a union is dealing with individuals within the union. And there is a very large range of types that become union delegates. You can see what's happening from Jeff Watson SC's reports into the construction industry and the type of people that have infiltrated unions and benefit from union operations, a lot of the time on the back of alleged safety contraventions, and they drive access and responses by claiming safety breaches and the right to come and inspect and the like. That doesn't
Mhm.
mean they have unfettered control, and there is a dispute process that is there. So if you do become involved in a dispute, it's time to get off to the Industrial Relations Commission.
Mhm.
Pushing back,
Yeah.
though, has its risks.
Yes, it does. And is there anything else you wanted to share for employers who might be concerned about these changes? Anything you want to add to the incredible discussion we've already had?
Don't be worried about unions. It's not the number one concern. It's a nasty shock when people think about it, but I don't think it's the real issue. The
Hmm.
issue is the extension of duties under the Work Health Safety Act, the new duty to comply with codes of practice, the new regulations that require us to deal with the psychosocial safety code, and in particular introduce and or eliminate hazards and introduce control measures. If anyone has control measures in place at the moment, I would congratulate them, because I think there would be a lot that haven't worked out what controls they need to put in place. And as you and I were discussing before we came on, the Institute is going to be trying to build those resources to support the businesses that will be confronted by these
Mm.
changes, these challenges, and preferably not prosecutions.
Yeah.
But they are here to stay. They can't be ignored.
Yeah.
There is two brand new sections, which gives two brand new duties and a whole new code that you must comply with. And it's a detailed code. It is very prescriptive. It tells you precisely what you should look at and what the potential hazards are. It
Mm.
does not give you the control measures that you need to implement to deal with them, which is something that codes will tend not to do,
Mm.
because they cannot, on one hand, identify a hazard and then eliminate it.
Yeah.
And so it's a matter of working. And safety systems and complying with codes is all about running a business properly and
Yeah.
making sure the business actually works for you,
Yeah.
and protecting your asset, which are your staff.
Yes.
So,
And I think that's a great way to end on it as well. It does seem scary. There are some things that can be scary, but it's all about having the right positive outcome and looking at prevention. And I think it's clear from, both of the episodes that we've done and will be doing in future that psychosocial safety isn't a nice to have anymore. It's a core compliance, work health and safety compliance with real enforcement teeth, as you said. But just wanted to say a huge thank you again for coming on and explaining this a bit more. For anyone who's listening, these changes are significant but manageable. And David has kindly developed an article, an extensive article, and we will link that in the notes below. And if you need legal advice specific to your situation, his contact details are there too. So thank you so much, David. Really appreciate the
pleasure.
conversation. And this has been a psychosocial safety briefing from the Institute. If you are not already a member, head to our website to access monthly expert workshops, ready to use tools, practical guidance, and on managing psychosocial risks. And as David said, we're here to bring more as well. So partnering with incredible people like you helps to give us to be able to create the tools that workplaces need to be able to manage it themselves and make it a bit less scary. So thank you so much, David.
My pleasure. Evening.